Good evening, everyone. Our guest for today has arrived, Miss Iram Majid, ma'am. Ma'am, can you put on your camera and audio, please? Good evening, ma'am.
Yeah, good evening.
Ma'am, can we start?
Yes, yes.
Thank you, ma'am. Good evening, everyone. My name is Shrishti Sharma, and I am a student of LLM one-year program pursuing specialization in mediation. And I have the privilege of moderating today's guest lecture on emerging trends in commercial mediation and arbitration in Asia Pacific region. It is my honor to welcome our distinguished speaker, Ms. Iram Majid, an eminent lawyer, mediator, and arbitrator, and a global thought leader in dispute resolution. Ms. Majid brings over 21 years of experience handling a wide array of cases, both inside and outside the courtroom. She is currently the Executive Director of Asia Pacific Center for Arbitration and Mediation and serves as Central Government Standing Counsel at High Court of Delhi. With advanced training from Harvard Law School, Pepperdine University, and ADR ODR INT Dubai, she has been recognized as one of the top 10 mediators in Asia Pacific region by BIMAC. Her expertise extends across multiple jurisdictions as she is empaneled with organizations such as United Nations Development Programme, WIPO, Delhi High Court Mediation Center. She is also the co-founder and Secretary General of International Federation of Mediators, France, and a respected academics and authors of book on mediation and arbitration. Today, Ms. Majid will share insights on emerging trends and opportunities in commercial mediation and arbitration in the Asia Pacific region, a topic of great relevance to students, professionals, and institutions seeking to engage with cross border dispute resolution. Without further ado, I would like to invite Hiram ma'am to impart knowledge with us. Ma'am, please.
Thank you so much, Srishti, and thank you so much, Deepshika, ma'am. I can see you also. So, it's an thank you so much for this opportunity to interact with the young mind and students. And as I understand that today mediation is something an arbitration, including ADR. ADR is something which is now becoming very common, and everybody want to join. Many of you want to join arbitration and mediation. See, every other day I keep on getting lot of requests on my LinkedIn and my emails on WhatsApp that how we can become arbitrator, how we can be into ADR profession, into this profession also. So today, not only I'll be telling you a little bit about ADR and what is the trend or the emerging trend in Asia Pacific, but also I will tell you that what all the steps and important things you can do so that you can also become ADR professional. So one thing is very very sure that this is very promising field, and suppose if you would like to go for the corporate field, if you would like to go for judiciary, if you would like to go for as an in-house counsel somewhere, or if you would like to go for litigation or a litigation lawyer, if you would like to go for teaching, so in every aspect ADR is something which is in the nucleus. So you cannot afford not to know ADR, because if you will be going for the in-house counsel or as a corporate, you will be doing what? You will be analyzing contract, or you will be drafting contract, and you will be into contracts. In those contracts, you will see the dispute resolution clause. That is one thing. Second thing is, if you want to go abroad, then also in international trade law or international commercial trade law, you will see only ADR and arbitration practice. If suppose you will be going for the litigation now, even more of most judges, because yesterday I came back from Odisha, where there was a second national conference on the mediation, and there are all judges from all states, Delhi High Court judges from all, High Court judges from all states, including Chief Justice from each states, and also advocate generals and mediators. And the discussion was around only that mediation and arbitration should be the first way of resolving your dispute. So that is for sure that even the judiciary, they focus on ADR and arbitration and mediation. So what I feel is that this is for sure that if suppose you may not be taking this as a career option, but you should know this as a tool which you should have in your kit. When tomorrow any client will come to you, you should not leave them without having this option. So when the client will come to you, at least you should be having these options, that this case is fit for arbitration, this case is fit for mediation, this case is fit for litigation, this case is fit for neutral evaluation, or this case can be good for adjudication. So at least you should be knowing all these aspects, that this case is good for which dispute resolution mechanism. So that is why I say that you can't afford not to know about ADR. So that is something which should be in your kit when you graduate after this when you will be graduating, right? So that is one thing. Second thing is that if suppose you see that I'm talking about ADR, and you see me, going here and there and doing a lot of things. And just now in my profile also, you heard that it is with the United Nations, it is with World Bank, it is with France, it is Paris also. So ADR is something which liberates jurisdiction. So if suppose you will practice into ADR, into arbitration or mediation, it liberates jurisdiction. You are not bound by any jurisdiction. You can practice anywhere, because it is not court practice. It is mostly it is tribunal practice, or it is institution practice. So we see that now we are having a lot of institution like ICC. We have institution in even United Nations for the mediation. We have institution for mediation in ICSID, arbitration in ICSID, and also in World Bank. So these are the major organizations where you see that even these organizations, for their disputes or for other disputes, they are maintaining panel for arbitration and mediation, so that you can get impaneled with those institutions. I'll come to the career aspect also in the later part of my discussion. But before that, I'm just trying to setting up a foundation for all of you, that why ADR is important, what you will get into it, how you can make your name, fame, and money. And also, this is very promising field. Not I have read anything about this profession, I am living this profession. That is why I'm telling you everything from my heart, from my experience. And whatever I feel, I'm telling you things from my experience, right? So that is after this, I would like to share that if I do not know how many of you know about ADR. Maybe I understood that the session was for LLM students, but I could see many students, so I do not know whether other students have also joined. So if suppose it's for LLM, I am sure that they know what is arbitration, what is mediation. But suppose many students have joined, then it is very difficult for them to differentiate between these two. So I do not know that there is a hand raise option or what. So can I get to know that how many of you know about ADR, the basic about ADR? Okay, good, good. Okay. So I can see 10 hand raised for understanding ADR. So let me tell you a little bit about arbitration and mediation, and then we will proceed further. So ADR is alternative dispute resolution mechanism, and this is not the way we do in litigation. Also, it is completely different setup. It is outside court settlement. And arbitration is not settlement, it is adjudication, while mediation is settlement. So what happen is, in arbitration, that the party, they will be having in their arbitration, in their contract, one arbitration clause. And based on that clause, they will be selecting their arbitrator. That is outside the court, they will be selecting arbitrator. They will select the venue, they will select the jurisdiction to conduct the arbitration, and based on that, they will be going for the adjudication. And this adjudication will be based on the pleadings and evidences. And thereafter, the arbitrator, who is the neutral third party, will decide the case and publish an award. This award is like a judgment. So that third party, that is a neutral third person, who is known as an arbitrator, he will publish award. And that award is final and binding as per the law. And law we have in arbitration, 1996 Act. Right? So this is arbitration. In arbitration, number one, it is adjudication process. Number two, it will be based on the pleadings and evidences. And number three, there will be two party who will contest their case. It will be more or less like litigation, Only thing is, the only difference is that it will happen outside the court, and you will be having the power to decide your arbitrator, right? So this is what happened in arbitration. Now come to mediation. Mediation is a dialogue. It is a way, like people say, compromise or so there will be two parties who will be having dispute, and they will decide, and they will find out their mediator, and the mediator will be neutral third party who will decide, who will not decide the dispute, but who will navigate the dispute with the communication and negotiation skills. So this is negotiation. It is facilitation. It will not include adjudication. So it will be decided with the consent of the party. So one is arbitration, which is adjudication by neutral third party, and one is mediation, which is dialogue and facilitation and compromise and settlement with the with, with within the parties, but with the help of mediator. So the role of both the neutrals are different. One role of the neutral is that they will decide and adjudicate, and one role of the neutral is they will facilitate with the help of negotiation and communication. So these are the two different, method which has been mostly used in ADR. So now, based on this, what you can do and how you can know the international trade trends or so. But before that, let me little bit talk about the arbitration law and mediation law. So for the arbitration, we conduct arbitration under the aegis of 1996 act, that is the act based on ancestral model law. So let me tell you that what is ancestral model law and what how we come up with this arbitration act. So arbitration is like an adjudication, like we had in panchayat system earlier, and it was very much in our society. And thereafter, when the Britishers came also, then we adopted the English Arbitration Act. So our Arbitration Act, the first came into existence, it was 1940 Act, and that was nothing but the copy cut paste of English Arbitration Act. And after 1940, we used to manage and maintain and practice into that act only. But internationally, the situation was happening differently. So the people, they are more into arbitration, and there are business communities who set up different arbitration practices, because if suppose in the cross border international entities, if they will be coming for any kind of business, so they will be having something in their mind. Let's say tomorrow if dispute arises, so how that dispute will be resolved. So before coming for any contract, they are very much mindful about that, how they will be reducing their dispute, or how they will be managing their dispute if it arises, because dispute and conflict are inevitable. So in that condition, they feel that there should be a mechanism like an arbitration, which should be having a uniform practice, and it should be based on the uniformity. Because let's say the person who is sitting in Indonesia, another person who is sitting in Malaysia, and these two people, if they are entering into a contract, and these two people, if they are entering into a contract, they should not end up into the technicalities of and the procedural technicalities of the court mechanism. But there should be a method which will be common in both the countries, or in any countries who are entering into a cross border business, so that tomorrow if any conflict arises, they can able to manage that with the uniform practice. And there comes the arbitration. So in 1985, the ancestral model law, they come up with the Model Arbitration Act. And that model arbitration act, it was like a model for anybody. So many countries, almost all countries, they adopted 1985 model law, that is called ancestral model law. And then what they India is also, they were following 1950 act, 1940 act. And after that, once the 1985 ancestral model law, that model comes up, India also followed that model, and in 1996 they decided to follow this model, and we copy cut paste the entire model law. Whatever the things which we are not able to adopt from ancestral model law, we adopted from English Arbitration Act. So our 1996 Act is nothing but the combination of English Arbitration Act and ancestral model law. And that is how in 1996 we comes up with the Arbitration Act. This Act is very much improved version of 1940 Act. And thereafter there were a lot of amendment, like in 2015 there was a first amendment, then 2019 second amendment, 2020 2021, and now if you see the entire arbitration act, we are coming with the new version in 2024. So 2024 bill is now pending, and it may come anytime. and we will see a new dawn of arbitration after this act, because this act is a much 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 improved version, and trying to hammer down all the loopholes which were there earlier in the arbitration act. So this is the history of arbitration. And if you come to the mediation, so mediation is something, this is very much close to my heart. And but we were not having law, and we started mediation in 2005. And I still remember that when there was a judgment. Based on that judgment, it was a direction to all the court to set up mediation centers. And then when we were into this setting up the mediation centers, so I was fortunate enough to be the part of that chamber. That chamber was instrumental in setting up the center in Delhi High Court. So that the faculty members or everybody, the group went to the Karkarduma court also, that is in Delhi. So that Karkarduma court, the lawyers resisted so badly, they ransacked everything, and they said that we don't want mediation, because mediation is something that will drop the revenue which lawyers are generating. So that was the mindset of these lawyers, and they ransack everything. Even they took the this taps, water taps also. They removed everything, all the structure in Karkarduma court, and they were on a strike, and they said that we will not welcome this mediation movement. But mediation is something which is which needs not anybody's support. It keep on flourishing. And I still remember that I entered into this mediation in 2009, and from 2010 onwards, I am into mediation. I am doing mediation, and my one of the most important mediation was when I appointed as a mediator, and I got to deal with a dispute which was pending for last 25 years. And you will not believe it is a matrimonial dispute, and husband and wife, they keep on fighting for last 25 years for getting the divorce. And husband got the divorce in 1 year, and this wife filed a appeal against that divorce, and then it is pending in the court, and that is how this matter is referred to me to mediate. And you will not believe, in the end, this husband is suffering from cancer, the mouth cancer, and he was about to die. And the wife is also pleading that my entire life is just I spend my entire life running to court, and running through the procedures, running after these lawyers. So can you please help me out? And you will not believe, within 5 days this dispute was resolved. And and what changed me completely into ADR is that after a week that the settlement agreement was signed by both the parties, because matter was settled, both the parties signed the settlement agreement. But after 1 week, this person passed away, husband. So that completely taken away my mind, and I felt that we have law, we have procedure, we have lawyers, we have courts, we have acts, we have amended acts, but even then there is no justice. Then I thought that I should do something, more into this field. And that is why I said that mediation will find its own way. There are lot of lawyer who has seen the dispute very closely, and like me, and we know that what parties are going through. They are not sane when they are into dispute, but through mediation, at least they will restore their peace, they will restore their relationship, and on the top of it, they will get the solution whatever they want. So the person like me, many lawyers, they started exploring more into mediation. So mediation is something which will find its way. It doesn't need any support. So when the lawyers who were against this mediation movement, even now they have joined this mediation, and everybody is now after that how they can become a mediator. And but the only thing was that there was no law on mediation in India. So people feel like they did not have any kind of trust. Not the people, but I must say the users, because this ADR is more than it is for the user. It is for the lawyers. More than that, it is for the users. So the users should find or feel trust in any system. So they were not feel that there is no law, how to go for the enforcement. If suppose there is international dispute, then how mediation will happen, how the enforcement will happen. That was completely absent. And that is why you see that I'll tell you one more international history, and then I will be able to connect both the arbitration and mediation scenario. So what happened is that we keep on talking about mediation law in all the conferences, in seminars, in classes or so, but it was not easy to get the mediation law. How we used to do mediation is, as per section 89 CPC, there is a provision that court can refer matter for the settlement. So by court pending matters under CPC, and we had this Arbitration and Conciliation Act. So in the name of conciliation, the conciliation word interchangeably used with word mediation. So with that, that 1996 Act, Arbitration and Conciliation. So where there is a mechanism for the conciliation award or the conciliation process, the same process we adopted for the mediation. So if anybody, they used to come to me before this act, even still, because act is not notified as yet. So even before that, if any party will come to me and they say, ma'am, we want to resolve our dispute privately without going to the court, even without filing any case, that is called pre-litigation mediation. So how we can do it? So I suggested them that, okay, you file conciliation application, and then we will be I'll act as an mediator and will pass and settlement agreement, and the settlement agreement will be under Arbitration and Conciliation Act. So it will be a conciliatory award, and it will be as good as award. It will be enforceable also, and it will be you can challenge it also. So that is how we used to find the way for the mediation. But if you see the mediation, either it will start through court under 89, or either through Arbitration Act. It was not having standalone act. So that was a problem. And many countries now, if you see in Hong Kong, in Australia, in US, in UK, all these countries, they used to have mediation law. So that is why they are much, much ahead from what we practice today. Then what happened is there was a slight shift in international ADR mechanism, or ADR scenario. So what change is that you must be knowing about United Nations. The UNCITRAL is the body of UN, and this UNCITRAL have different kind of working groups. So working group 2 is responsible for making any law for ADR. So I'm myself is an observer in and delegate in working group 2. I keep on going every year 2 times, one in New York headquarters, and second is Vienna, because two sessions happen for working group 2. So I joined for these two sessions, and I also make my recommendations with regard to ADR. So the recommendations happen in working group 2, and they say that there should be a requirement for having a convention, and that convention should be for the purpose of enforcement of foreign settlement agreement, mediated settlement agreement internationally. So there should be a convention. And way back in 1958, there was a convention that is called New York Convention. These two conventions are very important. One is New York Convention, and that is for the enforcement of foreign awards. Let's say this convention is that any country who entered into a contract with an arbitration clause into it, and if there is a dispute arises, and then after that, if those countries are signatory to this contract, this convention, then award made anywhere or award rendered anywhere who are the signatory to this contract can be enforceable in any of the country. So far, we have more than 170 countries who are signatory to New York Convention. So it was made in 1958, and that gives the requirement for coming up with the model law, uniform law. Similarly, here, first they come up with the Singapore Convention. The Singapore Convention came into 2019, and 2019 it the part the event was hosted by Singapore. I was one of the person who saw this historic moment. I joined this signing ceremony of this convention, and when this convention came into force, it was 7th of August and 2019, and I also went to Singapore, and then this Singapore Convention came into existence. At that point of time, around 46 countries signed this convention. So the idea behind this is also that whosoever entered into this convention and settlement agreement made anywhere of the world can be enforceable into these convention countries. So that was the idea behind this Singapore Convention. Now, when the Singapore Convention came into existence in 2019, that gave us a push or a need to come up with the mediation law, because we have to abide by all the conventions, and convention require the local laws. So that is what the Supreme Court and Ministry, they keep on pushing. They made drafting committees also, and I was also one of them who gave recommendation to the Parliament before the Parliamentary Committee while coming up with the Mediation Act 2019 2023. So we started in 2019, and we come up with the Mediation Act in 2023. So that is how we had 2023 Act, and that is how in arbitration we had 1996 Act because of the unsettled model law. And here also we have unsettled model law on mediation, and that is also in place, and we have followed that as well. But our Mediation Act is something which is very beautifully drafted. It covers everything. The only thing is today we are awaiting for the notification, that it is not yet notified. Only 8 or 9 sections have been notified. So that is what the scenario today. So what, so far I told you about arbitration, I told you what is mediation, I told you that what is arbitration history law, that we came in 1940, then 1996, and then few amendments, and now we are awaiting for 2024 Act. That is one thing. For the mediation, I told you that we never had anything, and with the one case law we come up with the setting of the centers, and thereafter in Singapore Convention 2019, and then there was a push to make a or come up with this Mediation Act 2023. So now this is the scenario for the for this field, as the if I talk about the law. Now if I say that how to go into this, how you can be into this practice, what you should do, how you should evolve as a mediator, as an arbitrator. So let me tell you that there are multiple areas or multiple field whereby you can check the opportunities. Number one opportunity I must suggest to all of you, for the beginners, that you should go and you should join as a legal counsel, right? So start from the case manager. Being a student, you can be the case manager. So who are the case manager? In I am talking both jointly, either it is arbitration or either it is mediation. Opportunities will be common, and I keep on telling you some institutions. I will keep on telling you that how or where you can send your emails and how you can get the opportunity. So now you know that the internationally the practice is same and common, right? It is uniform. If you understand arbitration here, you can practice arbitration anywhere. If you understand mediation here, you can practice anywhere mediation. The requirement is for arbitration there is no training. For mediation, yes, we required 40 hours training. And recently Supreme Court MCPC, because I am mediator in Supreme Court also, mediator Supreme Court MCPC, they have provided training for the student as well, 40 hours training. And I'll ask your college also to check with the MCPC. Otherwise I will coordinate for you people that how you can also get 40 hours training from the Supreme Court itself, because now they have started this endeavor for training the students. So many students I come to know that they have done, because it is online. You have to come only 2 times for the Supreme Court, otherwise you can do online. So that is a different and a separate quota for the students, because we need around 2 lakhs and 30,000 mediators in India to start this mediation movement. So that is about the mediation. So what you can do now, first let's see the what are the opportunities. Number one is you can be a case manager. Case manager is where you will be managing case along with the mediator, along with the arbitrator, and along with the counsels. So you will not be serving the counsels, but you will be attaching with the institution. So let's say I am a director from Indian Institute of Arbitration and Mediation, and also executive director for Asia Pacific Center for Arbitration and Mediation. So we do have case managers because we mark or allot cases to the arbitrator and mediator. And now we have digital legal case managers, like suppose if, because we are having one online dispute resolution platform, that platform also required a lot of case managers, because every case there will be a allotted case manager or the case manager. So you can be a case manager, you can attach with any institution. For that reason, it is not with any lawyer also, you have to attach with institution. Now many of you may be asking that what is institution. So institution are the organizations or the body which runs arbitration, which provide administrative assistance for conducting arbitration and mediation. They will be having a panel of arbitrators or mediators, they will be having rules, they will provide infrastructure, and also the legal counsels and case managers to carry out the administrative work. So that is how these institutions work. You see, ICC is an institution, AIAC is an institution, and IIM is an institution. MCIA, this Mumbai Center of International Arbitration, is also an institution. Delhi High, all the courts also, they will be having institutions, right? So you can attach with the institution. That is one thing. Second thing is that you can be a tribunal secretary. Now, tribunal secretary is something which is very emerging field, and many youngsters they want to become a tribunal secretary. And I think very few organizations in India they are providing training for tribunal secretary. So, what is the role of tribunal secretary in internationally or domestically is that they will be attached to one case, and with that one case they will be serving to the panel of arbitrator. It may be one arbitrator, or it may be a panel of arbitrator. So you will be assisting the arbitrator, and day to day file managing, making certain orders, or managing file or aligning documents and helping the arbitrator to conduct the arbitration. So that is a tribunal secretary. The role of tribunal secretary is very important, and if you see where you can get this role, you can get this role in ICC. So ICC Paris, you can apply for this tribunal secretary. You can apply tribunal secretary in Hong Kong International Arbitration Center. You can search on Google. You can see that Hong Kong International Arbitration Center, they don't only provide the opportunity to the youngsters for becoming an tribunal secretary, but also they provide the courses. That courses are also very good and very insightful courses. And Singapore International Arbitration Center, SIAC. SIAC is the most prestigious center all over the world. So SIAC is also provide opportunity for becoming a tribunal secretary. So this also you can do, and you can keep in your mind that tomorrow if you want to do something, being a student, then these things are open to you. Now, the third thing is that you can become a counsel. You can become a representative in arbitration and mediation. You can be a counsel. And fourth thing is that you can become an arbitrator and mediator, right? So that is something which is very obvious. You may not be impaneled with the court, you may not be impaneled with many organizations, but there are certain organizations which provide training and which provide empanelment. So you being into your third year, if suppose you are in 5 year course, so from third year onward, you are eligible to become empaneled as an arbitrator and mediator. And if you are in your 3 years course, from the first year onwards, you are eligible. If suppose if you are in master, then you are already late. So please join as early as possible any institution for the sake of empanelment, because that will help you and that is how you file. Once you become an arbitrator in any institution, you will get cases also, right? Institution will mark you cases, so you will be having a standalone or first hand experience of handling these disputes. So here I would like to tell one thing, and Deepshika, this is something which is very important to mention here, that we have come up with the this online platform. And this online platform, we are engaging students, fifth year and fourth year students, to become an arbitrator. So for that reason, in the many colleges, we have opened up this digital centers, and digital centers. So we will mark the case with the digital centers, and the center will allocate marks to their respective either teachers or their students. So this we have now started in 3 4 universities, and in those 3 4 universities, the students they are getting money also, and they are getting cases as well. And the teachers also they are involved, the academicians, because I feel there is a gap between the academician and how they practice arbitration. So that is how we have
Exactly.
allotted cases to the practice to the academician also, so that they can understand that how arbitration works. So they are doing arbitration, and it is
Yes.
online, and it is very easy to do because there is a step by step guide also. And for the
Okay.
award, there is a committee who will supervise the award as well. So that is how we are providing that platform. So if suppose the student who are interested, I'll discuss with Deepshika that how that can be done, so the student can be the part of this process, and they can be an arbitrator, they can be mediator. They will get a real time case, and they will act upon. And if you will be writing in your profile that I have rendered this much of award, see who will stop your selection in any firm or any dispute resolution firm. So that is the biggest opportunity, I must say, that you will be having. You may
Exactly.
not be having any guarantee after your degree, but this guarantee, I'm 100% sure that you will be ensure that this side career will be ensured, right? So this is second thing. Another thing is that you, if suppose you want to do internships also, so that you can do internship with international organization. So if suppose if I try to connect you with the Asia Pacific region, so SEAC provide internship for 6 months. So this is online and offline both. So you keep on checking the SEAC website and you can become the member as well. So I suggest all of you to become the member and also search for the online opportunities. The only thing is, suppose if you are doing online arbitration internship, that is not a issue. You should not worry that why I'm not able to go there also. That will save your money, but uh, you will be their intern and you will get to know all the work of SEAC institution, that is in Singapore International Arbitration. And second thing is they also provide membership, that is a young SEAC membership. And you being a student, you can get that free of cost. It 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 requires no money, right? And similarly you can go to ICC. See, if you will go to ICC Paris, I have seen few students from here, from India, they have gone there and they took accommodation for 6 months, because it is not lesser than 2 to 3 months. You have to go there for at least 2 to 3 months, and they stayed there and they did internship in ICC. See, that has changed their life completely. I'm not saying that immediately after the graduation they secure the thing also, but they are able to make their connections with those people to whom many of the lawyers they are seeking, right? So you can make your connections there by going for the internships. And the selection is also not very difficult, it can be done. Another thing is United Nation recap, that is the recap region is in Korea. So in Korea also they provide internship opportunities. Every year they open internship opportunities for 6 months, and it is regional it is residential internship. They don't provide online, so you have to go there, but again you will be doing UN work. So that will again enhance your knowledge and give you a vision, right? So these kind of exposure is very much required, because if you see, this is the Asia Pacific centers which provide these kind of opportunities, and many of us are not aware about these opportunities. So I must suggest you that you should go for these opportunities, because when I was a student like you, I did not get this opportunity, and I was briefed from this opportunity because there was no person who could mentor me. And I feel that if I could have got that opportunity, then at least I could be into ADR from my college days. Not like, because I spent my 7 years after my came into practice. Spent 7 years going here and there and understanding different procedural laws and other things and practicing in court. But you know it has taken away my 7 years. After 7 years I understood that my calling is ADR. So for you also, I must say that you should be aware about your calling. You should understand that what are the opportunities there in around Asia Pacific region. But not only Asia Pacific region. Suppose if you would like to go to World Bank, you would like to go to UN, you are free to go. You are free to go. In UK there are a lot of opportunities. You are free to go, right? So beside this, what you can do is you can become member of other institution like AIAC, that is Kuala Lumpur Center, that is based in Kuala Lumpur in Malaysia, and that also provide free membership. ICC provide free membership. And for the girls, there is an Arbitral Women, that is an organization which provides membership, which provides also aid and fund for the moot competitions if you are female. And they support a lot to the female this thing. And they if suppose you become member of these institutions like either ICC, either AIAC, either Arbitral Women. So what you can get, what is the benefit is they select the representative also, state represent country representative. They select the young representative, and that is how you will get a lot. See, what I am telling you, you may not understand now, but tomorrow when you will be in the field, then you will realize that how this much add to your profile. There is IBA also, like this International Bar Association. International Bar Association also provide the same opportunities. So you have to search for the international opportunities, international trend, and what is going on, and how. If suppose you become member, then you will be the part of this movement. You will become very very close to this ADR practice, and It is not something then you will be getting to know from others also. The moment you will become member, you will keep on getting updates from this organization in your email. You will get the all the opportunities of webinars, seminars, whatever the conferences are happening, they will keep on updating you. So that means you will be in the circle. So what I did when I wanted to be into this practice is, the first and foremost thing is I wanted to attach with the circle. So if you will not be in a circle, then you will not be updated with the latest trend. So I also did the same thing what I am telling you. I am see all these things because I have explored from the scratch. So I know that what it cost and how you get it, and what all the struggle you have to do to understand all these fields. It is not as that simple, but since I have decoded it, I have unlayered all those opportunities, I'm able to tell you all these things, right? So you can become the member, and it is free of cost, and you can get all the updates from these memberships, and you will get to know latest trend, and that is something which is very very important. They keep on providing lectures, lecture series, and sessions. So please attend that if you seriously want to be into this practice. That is one thing. Second is mooting and writing. Mooting and writing is also very important. There are journals, international journals. And one more thing, recently I have been to Malta in one conference where our few judges from the Supreme Court and upcoming CGI also part of that conference. So this is the Commonwealth Lawyers Association conference. So Commonwealth Lawyer Association conference is also having a junior group or the young group. So they also have a their representative who is the young representative. And so there are two parallel body. One is Lawyer Association Commonwealth, and one is the Commonwealth Young Group Association. So the Young Group Association, if you will join, you will get lot of benefit. Lot of benefit. It is a very very huge network. And why I'm pushing you towards the network? Because the network is more important than your work. You have to connect with the people to build yourself. Tomorrow when you will be coming out from the college, you will understand and realize that nothing is possible without having a network. You need indeed a network which will help you and support you. Otherwise you will not able to work alone in this field, because this is a very very wide field. You will lost. I have seen many students that they come every year in courts, and I cannot see them after 1 year or 2 years, because the retention is very low. Retention is very low, and it seems to be very attractive, but it is too competitive. 1700 colleges in India, and every college provides 100 students, and now you can calculate that how many students you know uh, they graduate every year, and how many opportunities are there, and how many law firms down the line, top tier law firm, 10 law firms, and how many students they absorb every year. So you understand that how things work. So it is very important to have a good connection and good network. And how you build network? By going to the competitions, by going to the conferences, by writing something, and by being associated with good chambers, good lawyers, institutions, judicial clerkship, and all these things. It is very important. And judicial internship, it is very important in this field. And now the last thing which I would like to tell you that is very very important, that is mentor. You need to have a mentor. If you are if you are going here and there without having any understanding, but you are ending up with wasting your time, wasting your money, and wasting your energy, and then you come to know that this is all waste and you have to start from the beginning again. So that is something which will be very very hectic, and it will not give you any kind of fruit. So that is something which is very depressing. So what I suggest you is that you should be having a mentor, and that mentor should be a guide, should be a GPS, with whom you will understand that you can confide in that person, and you can say that, see, this is the internship. If you have to internship down the line, which internship is good for me? That person can able to tell you that which internship is good. If you have two job opportunities, that person can be guide you that two opportunities, this is good for you. And if you have something in your mind with regard to the, or some confusion with regard to your your future career aspect, that person should guide you. It is not just for the particular subject or for the focus area, but that mentor, that guide can guide you for anything. See, why I'm telling you is because I faced a lot of difficulty with regard to all these things. I had no idea where to go. I had no idea what to do after completing my law. I have no idea whether I should be joining civil, criminal, or corporate. I have no idea that where should I go. Should I go to Delhi? Should I go to Mumbai? Should I go to other places? No idea. I just had one mark sheet in my hand and I came to Delhi with one tote bag, and I stayed near Supreme Court. There is a Aga Khan hostel. I stayed there, and luckily I was very fortunate to get a good chamber. That, but everybody is not fortunate enough. But that was also not something which was enough for me, because after that practice I explored things in arbitration and mediation. Until that time I did not get any mentor, and I was roaming here and there without any clue, and just I was just harping on everything. Somebody told me that Harvard Law University is very good for ADR. I went there. Somebody told me that Pepperdine University is very good. I went there. Somebody told me that you should do this training from IIM. I did it. Somebody said you do training from this. I did it. So I keep on doing everything without having any direction, without having anything. And I don't feel I'm not hesitant in sharing my journey with all of you, because everybody committed mistake, and with our mistake we learn a lot. So I struggle a lot. I keep on crying every day. I could not see a clear path, or vision was not very clear. But somehow I also got mentor, because when you have determination, when you have fire, you want to do something, then you will get a lot of good people who will support you on your way. So I also got a mentor, and that was something which I aspire. But आज मैं एक बात कहती हूँ सब लोगों से, कि हम सोचते हैं कि हमको मेंटर मिले, लेकिन आज जब मैं चाहती थी मुझको मेंटर मिले, तो उसके बाद मुझको मेंटर मिला, बिकॉज आई वॉज सीकिंग फॉर अ मेंटर बैडली विद दिस यूनिवर्स. लेकिन आज मैं ये कहती हूँ कि जितना हम मेंटर को चाह रहे होते हैं, उतना ही ज्यादा मेंटर को एक मेंटी चाहिए होता है, बहुत जरूरी चाहिए होता है. तो जब मैं आज किसी को मेंटर कर सकती हूँ, देन आई कैन रियलाइज दैट इट इज नॉट जस्ट वी mentee need a mentor, but mentor also badly need a mentee, because if there are people who are serious, honest, and people with integrity, we need those kind of people. Not me, I am saying we means collectively, for all the lawyers who are practicing, that integrity is zero these days, very less. So these kind of people everybody is looking. So I suggest you, please go and find your mentor. And sometimes people say, ma'am, how to find a mentor? So mentor and mentee relationship is something which is very very pious, very strong, and it is heart to heart connection. So ये मिलता है अपने आप, ये ढूंढा नहीं जाता, ये connect हो जाता है. So this is a connection, right? So whatever I told you today, it is from my life only. I took this small baby steps, but sometimes I feel regret that why I did not get somebody who could have told me all these things in my college days, so that I could have saved at least my 7 to 8 years. बट लेकिन वो 7 to 8 years ने ना बहुत इवॉल्व किया मुझको. आई इवॉल्व टू मच इन दो 7 to 8 years, because if those would have been a spoon feeding, I would have not been evolved, I would have not been a struggle. So your struggle gives you, a push and your reason to go beyond. Because whenever I look back, right, whenever I feel tired, I feel that no, now I should not go ahead. Now many all my friends has they are sitting, they are enjoying their life, why I am burning out too much, why I am struggling too much, then my that hard work keep on pushing me. नहीं भैया, पीछे इतना मेहनत करा है, अब उस मेहनत का छोड़ना नहीं है, आगे तो बढ़ना है. So that is how I keep on, taking baby steps. And those baby steps, the first and foremost thing was my LinkedIn profile. So I build my LinkedIn profile, and I keep on writing. When I used to get only one like or two like or three likes, but I did not stop there, because my idea was not to get like, but my idea is just to show my presence on social media. And that is not on the reel, not on the Facebook or so on the Instagram, but it is a professional connection. So there you make meaningful and professional connections. Suppose if you want to explore the opportunities in Asia Pacific region, not only Asia Pacific, but the world will be connected on LinkedIn, with you. And I'm getting my around my 50 to 60% work from LinkedIn. The people keep on looking at what I am doing, what are my activities also, and they keep on connecting, and they call me for teaching in global universities. I went to Tamashat University, Bangkok, and I taught there. I stayed there for 10 days, and I got my assignment. I got my assignment of United Nations from there. I got my assignment, for this Malaysia and other places, Indonesia, other places. So I got many assignment internationally from there itself. So what I suggest you is that you should not miss your LinkedIn presence or your profile, LinkedIn profile. If suppose many people say कि मैम हमने बनाया तो था लेकिन अपडेट नहीं किया, तो आप बनाओ और अपडेट करो, और अगर नहीं बनाया तो बनाओ, एंड यू विल से दैट मैम आई डो नॉट हैव एनी कनेक्शन, तो जीरो कनेक्शन से रिक्वेस्ट किसी को भी भेजो, बट यू शुड बी देयर. व्हाई? बिकॉज योर कनेक्शन इज मोर इम्पोर्टेंट देन your work. So your network is more important than your work. You have to build your network, you have to be there, you have to be present over there. If you are not there, believe me, either it is ADR, either it is other things, you are missing opportunity every minute. Every minute you are missing opportunity. And again, it is not something I have learned from anywhere. I am telling you with my experience. The moment I opened LinkedIn, I scroll, I could see one opportunity. The moment I explored, I could see one opportunity. Oh, ये conference हो रहा है, ये हो रहा है, ये हो रहा है. Many times I may not be able to get to know many things. So being a student, you also connect, you also make network, you also become member of this institution, you also join international competitions, moot competitions, writing, debate, all those things. And also there should be culture in colleges as well for this thing. So that is why we have opened up JDC, this justice delivery centers in every colleges. So we have now down the line 10 colleges in our hand, where we are setting up justice delivery centers. And in justice delivery centers, those centers, we will be providing real time arbitration work, and those students and teachers jointly, they are in the committee, and they will be taking care of all the cases. So they are doing arbitration and mediation. So this is what all, in 1 hour I could tell you about arbitration and mediation. And in the last, the most important thing is, this is a frequently asked question, where the student asked me that, madam, can you tell me that how much remunerative it is? So let me tell you that how much remunerative it is. um कैसे बताऊं से कि I'll tell you one case. There is a case in the name of Yokas. This is a Russian case, and the claim was the awarded claim. The award which has been given by arbitrator was 90 billion US dollar, and the lawyer who is the lawyer for the claimant, he got 50 million US dollar. I'm talking about dollars fees. And the counsel for the respondent जिसने केस हारा था, he got around 35 million US dollar. So this is what I'm telling you, international scenario, international case. See, now I am doing arbitration, construction arbitration. It has lot of good remuneration. Okay, I know how much fee I charge, and I know how much I pay to the arbitrator. So both the side, either you will be an arbitrator or either you will be an arbitration counsel. If the cases are good, let me tell you, I promise you, you will be having Mercedes Benz or Audi very soon. So that is how, it is. This is this much remunerative this field is. That is how people are running after this, and everyone, there is no retirement age, there is no problem with regard to the jurisdiction. Everybody is running after this. And we keep on having our sessions and the practical sessions on arbitration and mediation. This was the first and opening lecture, to make you understand that how remunerative it is, how good it is. And community is this much community, you can make your name and you can get the fame also very soon, because I am the one who worked for the name and fame, and money followed. So if you will work for the money, the name and fame will follow. So whatever it is, this field is is like celebrity kind of line, and you will be celebrity soon. So this is what I can say, right? If you have any kind of questions, if you want to know that how you can become, where you can do the trainings, how can you do this, I think your center will also provide those kind of trainings also. So if you have any question, please, I'm open to that. The 5 minute left, so we can have. Over to you, Deepshika and Srishti.
Thank you so much, ma'am. Actually, the session was so thorough in every questions we have in our mind, because we had just started LLM in mediation law. And when we start the session, my LLM students are also there. They are hearing. They were like, "What are the opportunities, ma'am? What can we do in that?" And I was actually telling them as a faculty, and I was asking that ki we will brought some people, we will ask some people who can actually give you, and the last portion of remuneration is actually the portion. Truly, very truly, कि how much we can earn, and you beautifully answer with examples. So I'll say, ma'am, this was a very informative session, and forget about students. I have my notes here. I am writing down everything. So I will ask. Thank you so much, and we will keep in touch. And I think students thoroughly enjoyed this session. Thank you so much, ma'am, for joining us today
Thank you so much.
and giving so much valuable information which is not available. Very, very true that without mentor, and I think today we got a mentor. We are very
हाँ हाँ
happy.
बिल्कुल.
So thank you so much, ma'am. Thank you for joining us today.
Okay, thank you so
Thank
much.
you. Thank you so much, ma'am. Thank you. Yes, everyone, we can leave now. Thank you so much for joining.
Thank you, ma'am.
Thank you, Pacha. Yeah, today's session was बहुत बढ़िया था ना